Hello friends, a very warm welcome to UnSarkari. I am Vikas Bhardwaj. Continuing our understanding of different aspects of democracy, in our previous lecture we have discussed the very basic and foundational elements of legislature. And continuing that understanding further, now we are going to discuss what legislation is. From legislature, now let's jump to legislation. The key words, that's what we say. When we speak about legislation, according to Salmond, legislation is the source of law. Very important quote, you must always remember legislation is the source of law. And according to Grey, official statements by legislative bodies. That's how it is. The two key words, one by Salmond, other by Grey. Both you must write down, must remember and memorize it. Legislation is the source of law. It is a very beautiful beginning of even your all answers. Now, what its etymology? Legis means law, and Laterm means to make up, to put or set. Legislature. And from legislature, we have legislation. That's how it is. The core idea is legislation because the process of creating law by competent authority is called legislation. The Parliament of India is an example of legislation as a supreme law-making body. We can also try to answer one question. If legislation is the source of law, why societies, especially in countries like India, still rely so heavily on customs and precedents? Customs हमारे यहाँ की ये रीति रिवाज हैं या precedents ऐसा हमारे यहाँ होता आया है. Why do we still rely so heavily? Because if the legislation is the source of law, why do this happens? Do try to write an answer because this is a very important question from sociology, from society, from political science, and from history perspective. Now, what is the broad sense of legislation? Because the definition of legislation includes all legal processes are part of legislation actually. All legal processes, court-made laws, contracts, and even statutes. Everything is part of legislation. Do Google and try to understand these terms in more details. We will discuss it when we take up things in detail. So, legislation will include all legal processes. Judicial precedents in India, if we say judicial precedents in India, where judiciary has created a kind of a law, if we use the word law for it, then Keshwanath Bharti case is shaping constitutional law. Constitution itself is law. But then Keshan Bharti case is defining the contours, defining the boundaries, defining the dimensions, how one has to interpret, how one has to go by it. So that itself becomes a law. So one question here is, should judges be considered lawmakers when their rulings reshape constitutional principles? What do you think? Please write answer from Indian judiciary perspective. Should judges be considered lawmakers when their rulings reshape? Okay, the key word here is reshape constitutional principles. There's such a long history for India. Think about it and we will discuss. Legislative will. What is legislative will? The legislative will means the all acts, okay, all acts of legislature, whether intended as laws or not. That is the will. The will of the house. Legislative will. ऐसा होना चाहिए, ऐसा हम करना चाहते हैं. It may be in the idea stage. It may be, in the draft stage. But the intention is there. So that is called legislative will. So parliamentary resolutions, motions, and even declarations. For example, emergency proclamation debates. This is an example. All these are part of legislative will. So they carry a lot of weight. So symbolic legislative acts carry as much weight as binding laws because we know legislative will is not binding, but legislative will is the reflection of the intent of legislature. क्या करने वाले हैं, क्या चाहते हैं, उनकी इच्छा क्या है, हमारा धर्म क्या है, ऐसा करके वो जताते हैं. That's why we say that legislative acts, the symbolic legislative acts, do you think they will be also equally uh, uh, you know important or having equal weight as the binding laws once they become laws? Very important to understand. Please do write a short note. Now let's come to strict sense, because after will, let's come to strict sense. Strict sense of legislation means the process of creating enforceable laws. Enforceable, which will be, coming into action. Enforceable laws by competent authority. Not everybody anywhere can do it. Competent authority. Enforceable laws by competent authority. For example, in India, Lok Sabha plus Rajya Sabha, they are passing bills and the president is giving assent. After only president assent, it becomes law. Before president assent, it cannot be. So does the president assent make laws democratic? After president give assent, do you think the laws are becoming democratic or it is merely a procedure? What is your opinion? Write and explain. Let's see the type of legislation. So according to Salmond, there are two classification. One is supreme legislation and other is subordinate legislation. For example, parliament is an example of supreme legislation, and state assemblies, they are subordinate. Subordinate in the sense that in the constitution they have also been given freedom, but they are subordinate when it comes to the parliament. So is parliament truly supreme? If it laws can be struck down by judiciary, do you really think parliament is still supreme? Will you use the word supreme or something else? That's how we have to do brainstorming and write an answer. Supreme legislation, the laws from sovereign authority, that is called supreme legislation, cannot be repealed by any other authority. No other authority can repeal. So parliament is a supreme authority in so many ways. For example, in union list, it is the parliament's power, center's power. In the state list, those state assembly, state powers, the federal power is there. So parliament's power under Article 245 to 243, if you read carefully, you will find it. My question to you is, does supremacy of the parliament clash with the supremacy of constitution? Do you think so? What you can make out, write an answer, and then only our understanding, our clarity will be emerging. So subordinate legislation, as I told you, one is supreme, other is subordinate. So law dependent on sovereign authority, and secondly, sovereign authority is deciding that these laws and these further developments can take place when it is giving power to others, delegation you can say, and they can be overridden. That means subordinate legislation, the parliament has given power to others to create laws, but then whenever parliament feels enough and wrong thing is there, then it can take it back. So state laws are subject to union laws, we know that, and delegated legislation is there by ministries. There are different ministries in order to carry out functions, in order to carry out so much of public welfare, that there are laws created. Every law cannot be created by the parliament. Lot of time, lot of energy, lot of delay will be there. So delegated legislation will still be under control of the parliament, or you can say the union government. So the delegated legislation, do you think it increases in efficiency or it is reducing accountability? What do you think so? So take an example and try to think and Google it and then find that delegated legislation is actually helping different ministries, whether it is Ministry of Highways, whether it is Ministry of Health and Family Welfare, whether it is Ministry of Human Resource Development, Ministry of Water Resources. Think about it, and you will find that how it works. That's why bureaucracy becomes very important. Colonial legislation means during the British rule, when it was making laws for India, when India was a colony and British rule was an empire that is under imperial oversight. For example, Government of India at 1919 and 1935, they were shaping colonial governance, they were shaping India for benefit of the Britain. So do you think colonial legislation lay the foundation for democracy? Do you think so? Lay the foundation for democracy, or it was a hinder to it? It was actually stopping it, creating a resistance, or actually it was promoting it? Give your illustration. Let's see executive legislation. What is executive legislation? Is executive agencies. That means the government. It is exercising legislative powers because these legislative powers are delegated to the executive by the parliament. Parliament is giving certain powers to the government to carry on important functioning. So, for example, ordinances. is an example of executive legislation issued by the president under Article 123. Go and check out on Wikipedia that how ordinances have been so important tool. Even Supreme Court have intervened many a times that central government may be misusing it. So that's why our question is, are ordinances a necessary emergency tool or are they a bypass of democracy? What do you think? What do you think? Write your answer. Judicial legislation, very important. Another type. Judicial court are framing rules. Court are framing rules for their proceedings. Which bench will be taking up what, how will be hearing taking place, what is the sequence, how they will be picking up yeah, when someone's case will be taken up and so forth. There are so many disciplinary and other constitutional values into it. So courts are framing rules for their proceedings. This is distinct from the precedent. Precedent means, like we have taken example of Keshwanand Bharti case or the basic structure doctrine. Now that is a precedent. Based on that, further evolution, further development can take place, but that will be not called as a rule. So court is framing rules for proceedings. For example, there are supposed to be the rules for digital, digital live streaming. Digital live streaming also demands certain rules. Supreme Court framing rule under Article 145. Go and check out what Article 145 says in details. So, my question to you is, should courts have the power to legislate their own procedures? Do you think so? Why and why not? Similarly, municipal legislation, very important. Local authorities are having power to make bylaws. They are given power to make bylaws because it is so difficult. It will be a chaos and it will be such inefficiency will be creeping down. That is why local authorities are having power to make bylaws. For example, building codes. So building codes in Delhi NCR will be different from Bengaluru, will be different from Mumbai, will be different from, say, Madurai and so forth. And also sanitation rules, waste collection rules, and even property taxes. So municipal corporation is having its own bylaws so that it can carry on the local administration in a very, very efficient way. So does local bylaws affect citizen more directly? Do you think so than national laws? What do you think? And please do illustrate your answer. Let's come to autonomous legislation. Autonomous bodies are there. We know you must have read big, big banners and boards. Autonomous body, universities and corporations and even churches and even religious bodies. They are framing their rules. For example, UGC regulations, Bar Council of India rules, and even IIT. They all are supposed to be autonomous bodies and autonomous institutions. If we say, then they are supposed to be more efficient. They are supposed to be more forward-looking. They must have more, thought-provoking and innovative contribution. But then there is supposed to be oversight on them also. So, question arises, should autonomous institutions enjoy legislative powers without direct public accountability, or there should be public accountability? It is because of public accountability that in spite of being autonomous power or autonomous institution, government appoints sometime whole-time director or even head or the vice chancellor and so forth, because they believe that many a times autonomous institution is not actually furthering the cause of the public. So what do you think? Should autonomous institutions enjoy legislative powers without direct public accountability, or there must be certain public accountability? If you think a public accountability must be there, then do write what kind of public accountability is possible. So how we can conclude? We can conclude that legislation, there is supreme legislation, no change, nobody can change it, and it is supreme, and it is what one can say that it is the key feature for a nation. Then subordinate legislation is there, multiple forms are there. We have discussed in brief: colonial, executive, judicial, municipal, and even autonomous. So Indian polity illustration, if I give you, then constitution is a supreme source, parliament plus judiciary plus local bodies are contributors. So when we discuss and debate on this, in a democracy, who truly make the laws? It is the parliament, it is truly making the law, or judiciary truly making the law, or the people truly making the law? Truly, it is the people actually, and that's how the whole thing churning goes on. So thank you very much for understanding and for moving forward, and do write your doubts and concerns at teamunsarkari@gmail.com. Keep on reading, revising, and also understanding clearly. Do as many rounds as possible so as to get success.